Good afternoon. Welcome back to some of you, and welcome to those of you who have not been with us earlier. I'm glad to see all of you here. We're delighted to have this opportunity, and it's my privilege to introduce this give a brief introduction to the final speaker, which is the highlight of the day. But first, I want to introduce some special guests who are here with us. Chief Justice Carlos Muniz of the Florida Supreme Court is with us. My dear friend and been my colleague for quite a few years now, and so I'm delighted he was here. He was able to join us today. We're also joined by Tim Serio, who is the Vice Chair of the Board of Governors at the Florida University System. University of Florida and the University of Florida Law School. And then also Dean McAllister is here with us today, and we're very glad that she's here. And again, I thanked the law school earlier for making this facility available, but we really appreciate it, and we appreciate very much the cooperative relationship we have with the School of Law. But now, to our final panel, or our final part of the conference today, the keynote address. The keynote address today will be given by Dr. Adrian Vermeule, as you know. Dr. Vermeule is the Ralph S. Tyler Professor of Constitutional Law, and his remarks today will be on the subject of how dictatorship and prerogative became irrelevant, or how lawyers killed the fun. And I love that title. And I will now defer to my colleague, Professor Leibovitz, for a more proper introduction from the professor.
Thank you, everyone, for being here for what promises to be an incredibly stimulating and energizing event. We are, of course, honored to be joined tonight by Professor Adrian Vermeule for the keynote, whose title, How Dictatorship and Prerogative Became Irrelevant, or How Lawyers Killed the Fun, promises a sharp, polemical, and irreverent discussion of an urgent topic in public law, making it a perfect encapsulation of Professor Vermeule's distinctive academic style. Vermeule is the Ralph S. Tyler Professor of Constitutional Law at the Harvard Law School, from which he also graduated. Don't hold that against him. He is the author or editor of 11 books at last count. This could be updated at any moment, whose topics include constitutional and administrative law, jurisprudence, institutional design, and the theory of democracy. He is the editor, with his colleague Cass Sunstein and former Justice Stephen Breyer, of the leading casebook in administrative law, a role that confirms his place as one of the nation's foremost experts on that topic. During the long war on terror, Vermeule established himself as an indispensable voice on the topic of emergency and executive power, often defending the robust exercise of these powers in ways that sometimes scandalize the mainstream academy. Among his many works on this theme, we might pick out The Executive Unbound, after the Madisonian Republic, co-authored with Eric Posner, as being of special relevance for today's conference. More recently, and perhaps more dramatically, Vermeule has reoriented the field of public law with his ongoing work on common good constitutionalism, a wide-ranging scholarly project with, as is typical, a sharp polemical edge. The work has vaulted technical discussions of classical, that is to say, Roman and Christian legal sources to the forefront of contemporary legal debate, not only in Europe, where these ideas have always had some purchase, but also in America, where they have long been terra incognita. And its slashing and multifaceted attack on originalism has unsettled what had been until recently in a rather unquestioned dogma of constitutional interpretation. In addition to his small library of monographs, Professor Vermeule is the author of well over 100 articles and book chapters, which have appeared in venues as diverse as the Harvard Law Review, Constitutional Commentary, and most importantly of all, the Oxford Handbook of Carl Schmitt. His work displays an enviable command of several highly complex fields, the classics of social and political thought, Roman law, American administrative law, and decision theory, and we could go on, but I won't. His fusion of a humanist's range and erudition with his technical legal expertise makes him entirely sui generis in the modern academy, uniquely suited to comment on great questions at the intersection of law and politics. He has delivered distinguished lectures in most of the world's prestigious universities, and tonight we are enormously grateful to have him in ours. Please join me in welcoming Professor Vermeule.
Thank you all. I just want to clarify about the title Dr. Vermeule is not one I'm entitled to. I was just on a podcast recently joking about how if you're a Juris Doctor, you call yourself doctor, then the PhDs sometimes look askance at you. So I'm a mere civil lawyer. And I'll try to be polemical and irreverent, Adam, although it's kind of contrary to my theme today, which is killing the fun. And I'm going to try to explain how lawyers drained the fun out of dictatorship and prerogative. And I want to start with a quotation from Justice Antonin Scalia, looking over at Gary Lawson. And Justice Scalia said this. He said, "The main business of a lawyer is to take the romance, the mystery, the irony, the ambiguity out of everything he touches." That's our main job. And that's what I'm going to do with our conference topic today. I'm going to offer a jurist view of dictatorship and prerogative. Let me define my terms. I mean dictatorship in the Roman sense, the real sense, not in whatever loose sense one subsequently hears. It's extraordinary imperium, conferred ad hoc on a designated special magistrate through established procedures. And I use prerogative in the classical common law sense. To mean potestas extraordinaria, that is, the extraordinary power of the crown to take action beyond or even contrary to the ordinary law in cases of necessity. Okay, so in the spirit of Justice Scalia's act, my thesis is deflationary. I'll argue that these categories of dictatorship and extraordinary prerogative became pragmatically irrelevant to American law and the American constitutional order, especially over the course of the 20th century. I don't at all deny that dictatorship and prerogative are of great interest to legal historians, and they're interesting for the political philosopher and political theorist, to be sure. Adam Leibovitz has shown in very illuminated work that dictatorship was a sort of possible counterfactual for the American constitutional order. Many people discussed it in Republican terms in the founding era. But from the standpoint of the American civil lawyer in 2025, these concepts are merely theoretical interest. Why is that? The basic argument will go like this. Dictatorship and prerogative, from the civil lawyer sense, are a response to exceptional situations. But our law contained from the beginning and developed more and more fully over time alternative legal mechanisms for coping with the exceptional. And those mechanisms turned out to offer decisive practical and rhetorical advantages over dictatorship and prerogative. And in that sense, we kind of updated legal technology, especially over the course of the 20th century. What was the technological update? It was making the ordinary law of executive power delegated by constitutional and statutory provisions both more capacious and more flexible in interpretation. So there's rarely any need today for a toggle switch from the ordinary constitutional order to some extraordinary state of the constitutional order. The baseline of ordinary law of executive power is already extremely capacious and flexible. Putting aside, crazy hypotheticals, I mean, for almost any of the live legal issues that come up with respect to executive power today, the executive branch lawyer can, with a straight face, point to some mix of statutory and constitutional authorization for what the president wants to do. It's not to say that the president always wins, but there's so much delegated discretion that much of the time there's a straightforward argument for the legality of executive action. And in that world, dictatorship and prerogative become of largely antiquarian interest. Now, we can debate precisely how broad the ordinary law of executive power is today. I've had debates with my colleague Jack Goldsmith about this. He thinks it's a little more constraining than I think it is, although I haven't heard much from him in the second Trump administration, so he may be coming around a bit more. But my point isn't about the breadth of executive authorization. My point is about the terms of debate. The terms of debate are within ordinary statutory and constitutional interpretation. It's dry as dust, ordinary lawyers' work. That is, one almost never has any need in an actual executive power controversy today to speak of common law prerogative or dictatorship or anything extraordinary. One is doing things like pointing to Section XYZ of the International Economic Emergency Powers Act and debating exactly how broad it is, and it's all within the game of ordinary lawyering. So that was the basic update, depending on how you count that, it's executive power 2.0 or 3.0, but it's the juristification of executive power. Now, of course, as any iPhone user will tell you, not all technological updates are good. I mean, you may get the new update and realize you wish you stayed on iPhone 12 or whatever it was. So, of course, the normative Republican political theorist is perfectly free to say that this update is bad. We want to go back. The normative Republican political theorist could say that it's better to have a system in which the ordinary baseline law is more constraining, and then we have a sharp toggle switch to extraordinary states of affairs. That might be true, but I believe with Ronald Dworkin, and some people have an allergic reaction when I use that name. I think he was right about some things, wrong about other things. I think he was right about this, that the civil jurist has to care as much about fit as about justification, has to kind of try to make sense of the path that our law is taking. And for the civil jurist who's interested in executive power in 2025, the most striking fact is the breadth and flexibility of the baseline of ordinary executive power. So my reaction to the normative claims is it's something like this. This is an analogy. Suppose someone says that America would have been a better place if we had industrialized through the use of canals and dirigibles rather than trains and highways. And that was actually a possible future for American economic development. There's an interesting book on this. But for the lawyer in 2025, the only reaction to that is to say, well, I don't know, that's not what happened. And we have to try to make sense of the world that we're in. Okay, so that's the basic argument, and I'm going to now go through my two basic legal mechanisms that created this state of affairs, delegation and flexible interpretation, and just give a few comments about them and try to tell my story a little bit. And I think it picks up nicely from what we had earlier in the day, because the latest period we got to earlier in the day was about mid-20th century with Clinton Rossiter and the worries about presidential dictatorship and constitutional dictatorship. The heart of my story is going to be from the mid-20th century onwards. It's from the Youngstown case, right at the middle of the century, onwards to today. But before I get there, I just want to give a few background comments, both about the Roman case and about our founding, just to clarify some concepts. In the Roman case, I won't belabor the details of Roman legal history, but I want to note that we do see, over the course of the collapse of the Republic, the chaotic interregnum, and the legal crystallization of the Principate, we see a kind of substitution between dictatorship on the one hand and other mechanisms. And this substitution is close to the heart of my story. What is the substitution? The actual dictatorship in the technical sense withers away over the course of the Roman Republic. It's not used frequently or at all, and it's not used for about a century until we get the deviant or variant forms in the cases of Sulla and Julius Caesar. I think it's perfectly possible to argue those aren't really dictatorship as a classical lawyer would have understood them at all. And then we get the development of two other mechanisms that start to look more and more like what we would today call delegation. One is the development of the senatus consultum, which in the case of Cicero, for example, is supposed to at least confer some sort of extraordinary, maybe not legal authority, but extraordinary aura on consuls in crisis situations. And then we get things that look very much like delegations to particular individuals of broad standing authority. So we get things like the Lex Gabinia and the Lex Manilia for Pompey, for pirates, and for the war with Mithridates on the other. And we start to see these delegatory instruments. What happens then is the dictatorship is actually, it's abolished in the chaotic interregnum between Republic and Principate. When Augustus takes over, the Senate tries to confer the dictatorship on him, or offers it to him, and he rejects it, very interestingly. And he rejects it, no doubt, partly for reasons of political optics, because his adoptive father's great uncle had held it. But also because he didn't really have need of it. That the legal position of the princeps was such that, with an impressive collection of other magistracies, the dictatorship was not so critical. And then, over the course of the Principate, we start to see the development of these leges de imperio. Our sources, as Benjamin was discussing, are not very good on this. We have this one decent example that Cola di Renzo discovered in a church in the 15th century that's a law giving Vespasian very sweeping powers at his accession, and it's probably part of the sort of thing that the imperial jurists were referring to in the Justinianic Code when they say the basis for the authority of the emperors is delegation. It's that the Roman people have conferred upon the emperor all their imperium, their legal authority, and potestas, their power, through a lex, through a statute. And we know that this one that was enacted at the accession of Vespasian was approved, roughly speaking, by both the Senate and the popular assembly. So that's the official sort of legal basis for the Roman imperial authority. It's not dictatorship in any way, it's delegation from the Roman people. And the difference is, the delegation is a standing authority. It's not triggered by some extraordinary situation. It's not for a special type of magistrate. It's a standing authority at the apex of the system. Now, I don't want to make glib analogies from the Roman development to the development of the American case, but I think it would also be kind of blinding oneself to reality, not to see that the American case develops in a way that's not totally unlike the Roman case. And let me explain. We go from the founding era, in which dictatorship is discussed as a live possibility, although rejected, as I'll get to, by Hamilton and others. And we also see extraordinary prerogative asserted throughout the 19th century. But all that withers away, and what takes over is delegation. In some sort of parallel to the Roman case, what takes over is a broad array of standing delegations. Gary brought up earlier that the Supreme Court tries to resist this in the Schechter case in 1935, but the great irony of our history is that although Schechter invalidates the National Industrial Recovery Act, which would sort of the closest we've ever had to a literal American lex regia, the substance of the powers it conferred is just recreated over the ensuing decades on a kind of area-by-area basis. And we get sweeping delegations to the presidency that cover essentially the whole terrain of the domestic economy. Well, if I'm right, all this is based on a kind of substitution mechanism of discretion. That is, that dictatorship and prerogative become unnecessary because standing delegations substitute for those things. Is there any evidence that the actors themselves understood this way? Yes, there's abundant evidence, and it starts in the founding era. It starts with Hamilton, both at the Philadelphia Convention and in the Federalist Papers. At the Philadelphia Convention, he says, if you establish a weak government, you must at times overleap the bounds. Rome was obliged to create dictators. That's not an argument for dictators, it's an argument that if you want to avoid a dictator, you should have expansive standing delegated authorities. And Hamilton / Publius argues for this in many ways throughout the Federalist Papers. We get to Federalist 20, which is this famous mini treatise on the pathologies of the Dutch Republic. As a Dutch American, this really hits me. Hamilton in Federalist 20 says, tyranny more often grows out of the assumptions of power called for on pressing exigencies by a defective constitution, by which he means an overly weak constitution, than out of the full exercise of the largest constitutional authorities. So the idea is, if you're worried about tyranny, you should delegate to the government generally and to the executive broad standing authorities, precisely so that they don't have to burst the straitjacket of the law in an emergency. And that's very much the path that our constitutional order took. Article 2 is cast in, I think, deliberately both capacious and ill-defined terms. It vests the executive power of the president. It gives a short list of specific powers and says the president shall take care that the laws be faithfully executed. The debates on this go on, and you see originalists who do very specific level legal history, passionately convinced that they know what Article 2 means, but they're all passionately convinced in different directions. And I'm, of the school that thinks that with Justice Robert Jackson, who said that the materials bearing on executive power are almost as enigmatic as the dreams Joseph was called upon to interpret for the Pharaoh. That is, these materials are not well defined. What partly filled in the ill-defined boundaries of the executive power in the 19th century was this common law tradition of crown prerogative, which became a set of legal concepts about executive prerogative. These concepts of executive prerogative manifested themselves in a number of ways. For example, does the presidency have a protective power? Is there so-called inherent protective power of the presidency? This comes up with respect to presidential action not authorized by statute. It's intended to protect federal functions and instrumentalities and personnel. The classic case is a case from the late 19th century. It's got a real Wild West feel where the president, acting without any statutory authority, sends a U.S. Marshal to protect a Supreme Court justice who's being stalked by an assassin. And there's this dramatic encounter on a train in California where the assassin tries to kill the Supreme Court justice. The U.S. Marshal shoots the assassin dead. The U.S. Marshal is then tried for murder in the California criminal court. And the Supreme Court says that even though the president had no statutory authority to do this, that the president has an inherent protective power, and that federal exercise of power trumped the state law so that the U.S. Marshal cannot be criminally prosecuted. And the Supreme Court wrestles with the boundaries of this extraordinary prerogative as well, and they eventually settle on a bifurcated view, especially in a case called Curtis Wright, which bifurcates the crown prerogative that we inherited from Great Britain, and they're quite express about this. This is what they're doing. It bifurcates the crown prerogative from Great Britain into foreign and domestic spheres. And they say that in the foreign sphere, the president alone speaks for the nation. In the domestic sphere, it's complicated. There's some complicated allocation of power between Congress and the president. What is exactly that allocation? Well, it's not clarified to this day, but the locus classicus, the leading attempt to try to classify on the domestic side is Robert Jackson's concurrence in Youngstown v. Sawyer. And he separates presidential powers into three categories. He says category 1 is presidential power authorized by a delegating statute. Category 2 is where Congress is silent and the president is acting on inherent authority. Category 3 is where the president is acting on inherent authority in the face of a clear statutory prohibition from Congress. Well, there's always been action in Youngstown Category 3. This court has several times said that presidential inherent power, if it's conclusive and preclusive, can trump even a clear contrary statute. It said that for power to recognize foreign nations, the power to remove executive branch officials, and certain forms of presidential immunity. But in general, Category 3 has not been the main locus of action in American public law. The main locus of action in American public law since Youngstown has been Category 1, that is delegated statutory authority. And Justice Jackson predicted this. He said, as an alternative to extraordinary emergency action, he said, listen, more and more we see delegated discretion from Congress to the president. And he referred to a list the Attorney General had compiled of, at that time, 99 statutes that had granted the president discretion to act in emergency circumstances. And Jackson said, this is going to be the future of our law, and he was right. From mid-century onwards, we get ever more expansive discretion until, in 1989, Justice Scalia writes that the hallmark of the American state, the hallmark of American public law is broad discretion from Congress to the executive branch through delegation. I know there are a lot of non-lawyers in this room, I don't know into how much detail I should go, but I just want to give you a little bit of a flavor so you get a sense of the landscape. The Communications Act of 1934, which has since been updated, but it's still the basis for our communications law. It contained over 100 separate statutory provisions authorizing the president to regulate in the public interest, authorizing the Federal Communications Commission to regulate in the public interest. And this type of delegation was upheld after the Schechter case in the context of World War II by the court in a case called Yates, which is in some ways the foundation of our modern law of delegation. And there's just thousands of provisions in the code that authorize an agency or the president to make rules in the public interest or to make reasonable rules and regulations. Of course, there are specific statutes too. There's the Clean Air Act, which notoriously has very specific provisions, but that just creates more fodder for the debates of lawyers. Lawyers then debate about how far does this particular grant of authority go, how far does the Clean Air Act go, and so on. And a lot of what used to be exciting becomes my specialty, administrative law, where we argue over grants of discretion, we argue over the rationality of exercise of discretion, we argue over whether the record was adequate. But you see, the jurists have now seized on all this fun stuff about crown prerogative and dictatorship and so on, and they've turned it into legal work. And all high-level talk is kind of swallowed up in ordinary lawyering under the Administrative Procedure Act. Well, there's this thing that floats around in American public law called the non-delegation doctrine. I'm looking at Gary because I think we might have opposite normative views, but exactly the same descriptive view. I'm not sure. The non-delegation doctrine tries, in its mainstream form, tries to identify statutory grants of authority so broad or so discretionary as to amount to an unconstitutional transfer of legislative power to the executive. Problem is the court stopped enforcing the doctrine in 1935. And in recent years has several times rejected the renewed wave of non-delegation challenges. As a partial substitute, the courts developed some principles of statutory interpretation, saying Congress has to speak clearly to grant authority to resolve questions of major economic and political significance. On the other hand, the Act doctrine may or may not even apply to certain categories of presidential action. We'll know a lot more after the tariffs case this term. But this is my point, that all this stuff has become fodder for debates over the nature and limits of some canon of statutory interpretation rather than limit the nature and limits of the power of the crown or the dictator or the commissar or whatever. Okay, I think that it's not too exaggerated to say that if we look at the sum total of statutory and constitutional delegations to the American presidency, it's our analog of a lex regia or a lex de imperio. Of course, the collateral institutions are different. Of course, the president is elected on a 4-year cycle and so forth, but at any given time within the office, we have created a magistrate who, in some way, through delegation, overshadows the rest of the constitutional order. Now, we can talk about whether that's good or bad, and I'm not discussing that. But my point is that the lens, the category with which to understand that is neither prerogative nor dictatorship. It's delegated discretion in the work of the administrative lawyer and executive lawyer. Well, my final part is about interpretation. And this is, I think, the stuff that's hardest for like the non-lawyers to see, that people who are interested in political theory and so on, because you really have to get into the case law to understand this stuff. But even when there are expansive grants of statutory discretion to the president, they're then made even more expansive through loose and flexible interpretation. So I mentioned the tariffs case. The sort of ancestor to the tariffs case is a case called Dames and Moore versus Regan, in which, I'm curious if any non-lawyers in the room have ever heard of this. This is exactly an example of what I mean. Dames and Moore versus Regan involves in President Reagan's attempt to settle the Iran hostage crisis. And what he did was, under the International Economic Emergency Powers Act, he said that Americans who had made legal claims against Iranian assets in U.S. courts would have their claims extinguished, and those claims would be transferred to the Iranian government. And the idea was that we would essentially put all the property into a pot and deal with it like a bankruptcy problem. Well, the court acknowledged there was no specific statutory authority for this. It was very unusual, if not unprecedented. But what the court said is, the general policies of the statute support this. That is, the idea of settling international economic crises. It said that Congress has long acquiesced or kind of not objected to presidential action in this area. And the president also has inherent foreign affairs authority, and the statute is kind of multiplying or amplifying that inherent foreign affairs authority. And so this gets upheld without any specific statute saying you can do this. It gets upheld on, I don't know, Congress had gestured in the direction of presidential authority, if you like. Well, I won't go through all sorts of other interpretive moments and doctrines that have expanded delegated discretion. I just want to mention a few things focusing only on the presidency that I think political theorists may not see these, or they may not be visible if you're not a lawyer, but they're actually quite important in terms of the legal position of the presidency, and some of them I think are shocking when you come at it cold. First of all, the Administrative Procedure Act doesn't apply to the president at all. His action is not subject to that fundamental charter of the rationality of executive action. Injunctions don't issue against the president in his official capacity. So that's why they're very careful in these cases to enjoin lower level officers, but not the president directly. The president is absolutely immune from civil damages based on his official acts, and as Trump v. United States said, absolutely immune from criminal prosecution for official acts within his exclusive and preclusive powers, and presumptively immune for official acts outside that domain, and the list goes on and on. Our law, by and large, our public law has become, in my view, over the second half of the 20th century and the 21st century, more and more executive-centered. That is, if we look at the small c Constitution of the American state in 2025, which bears, some rough but also loose relationship to the written Constitution that we usually talk about, the big C Constitution, our small c Constitution is a constitution centered around this one dominant magistrate who in some way overshadows the rest of the constitutional order. And I'm trying to say that as objectively as I can. I think it's just kind of what the, if you imagine the jurist from Mars who comes down and tries to give a fair description of our constitutional order, I think that's what they would say. Most of that was accomplished through delegation and interpretation, not through prerogative or dictatorship or these other categories. So that was my message, and I feel bad in a certain way going to a conference on dictatorship that I give this deflationary message. Again, that's what lawyers are good at, and maybe the only thing we're good at is deflating people. So as a colleague, I apologize, but as a jurist, I'm unrepentant. Thank you.
We'll now take questions from the audience. So we'll do a call shot here. I believe we'll be passing on the microphone. So if you do have a question for Professor Vermeule, please just raise your hand, and the people with the microphone will find their way to you.
I see Gary over here.
Well, I don't need a mic, I project
Okay.
very loudly.
Yeah.
No, for the people who are here, I disagree sharply on constitutional methodology, on normative political theory, but the description of events is absolutely dead on. I'm going to try my best to channel, Jack Goldsmith, and at least make something.
Yeah.
I wonder if the one remaining constraint, since all the others, I agree with you, have long since disappeared, is fiscal.
Right.
And that is, the president decides that a value-added tax would be just a terrific idea to raise revenue. The president still can't do that. And the president decides that shifting massive resources into immigration enforcement would be a great idea. There's some capacity to move funds around, but it's actually constrained. And presidents still need provisions in big, beautiful bills in order to do that. So I'm just wondering if you would see any significance, or is that constraint also something that's just 20 years from now we'll be looking back and laughing and saying, yeah, of course the president gets to set the tax rates and spend whatever, appropriate funds from the treasury without a law.
Yeah. So of course I agree with you at the level of kind of formal law that the president can't spend without an appropriation. That's a kind of axiom of our constitutional system. But, and there are a couple buts. One is that there's a lot of reviewability doctrine that makes it hard to challenge the allocation of funds within the executive branch, especially under lump sum grants. So Congress has to be very specific if it wants to avoid that. And the same reasons that, good or bad in debate, the same reasons that have caused Congress not to be, or chronically not to be specific with respect to substantive delegations, will also cause it not to be specific with respect to appropriations. And so you get the same kind of dynamic on the appropriation side combined with broad executive discretion to move funds around different programs. The second thing is, even when it comes to so-called literal impoundments, I don't want to get too technical and bore people, but even when it comes to literal impoundments, there are increasingly substantial obstacles to reviewability. So the DC Circuit, which is probably the second most important court in America, has, especially in recent years, developed this very robust doctrine about limit on non-statutory review of presidential action that makes it hard to get review of impoundment. It comes from a case called Dalton versus Specter, and essentially what it says, this may sound shocking. I actually hope it's shocking, because whenever I think about it, I get a little bit shocked. This doctrine says that a mere violation of a statute by the president is not itself grounds for a constitutional claim. So if you have read Youngstown, you might think, well, isn't that definitionally true? If the president exceeds his statutory authority, hasn't he then violated the duty to take care that the law be faithfully executed? Well, this case, Dalton v. Specter, that the D.C. Circuit has now expanded, says, no, that's not true. That the mere stepping over a statutory line is not a constitutional problem. That means there's no non-statutory constitutional review against the president, and that's blocked several impoundment challenges lately. So I may be getting too technical, but this kind of executive immunizing law is expanding to the impoundment area as well. Oh, sorry. Okay. That was someone telling me I'd gone on too long. Thank you. Yeah.
Could I ask a question?
Oh, please, yes.
So I just wanted to, it strikes me that what you describe is racist and convincing. But I did want to pressure this notion of delegated discretion a little bit and ask you how much of that, I presume you mean Congress is delegated discretion, so the representatives of the people are doing this, rather like regular mode.
Yeah.
But of course, some of it is being done by the Supreme Court itself. And so I want to ask you about that balance. And one example would be, for instance, the overruling of the legislative veto, which is an important part of various delegated authority that was meant to control it.
Yeah.
So how much is the court responsible for the augmentation of discretion upon the executive? And then also maybe you could speak to the executive initiative itself in terms of approaching, particularly in areas of national security.
I think there's no one thing going on. If you had to, whether for good or ill, if you had to assign primary responsibility to one actor, it would be to Congress. Because the legislative veto problem wouldn't exist were there not, a package of delegation, including the legislative veto in the first place. Does that make sense? Yeah. Now, it is true that I think a lot of the Supreme Court's jurisprudence in the second half of the 20th century has been executive favorable, as we've been discussing. What's chicken and egg, though? Is that because the court has independently, for some reason, taken to expand executive power? Maybe in some periods that's true. But another factor is that they're quite aware that the long-term policy of Congress as a continuing institution has been delegation. Does that make sense? Yeah. So I think it's both, but I have to say that Congress has been the primary motor. There's one other factor to discuss here, which is a guy, a law professor named Kurt Bradley, has written about, which is the kind of long-term trend towards the expansion of executive power has a kind of legal sociology clause in addition to the other clauses, which is executive branch lawyers are always on the case. They're always there proposing new canons of interpretation, expanding executive power, and the other actors in the system are kind of more contingent and random. There are different political constellations and so on, but the executive legal establishment is constantly pushing the ball down the field, and that's part of the story as well. Yeah. I don't know where to begin. Let's just go this way. Yeah, please. Yeah.
I was just wondering if you could comment on your opinion on whether you think this trend is necessarily negative for the future of the country, or could go either way.
Oh, my normative evaluation? I have this bias. I'm not sure where it comes from, but I tend to think that if you see a very long long-term institutional trend. It's unlikely that it's just arbitrary path dependence. I think it's responding to some real need or other. I mean, I think in the American case after World War II, frankly, it's responding not only to the increasing complexity of the economy, the increasing size of the country, but it's responding to the needs of empire and the growth of kind of American global power. And that sort of set the path for our law. So one way of understanding the normative question is, and this is a Montesquieuian thought, but you want the law to be in some sense in equilibrium with the actual conditions and circumstances of your polity. Does that make sense? I tend to think this very broad executive favoring law is roughly in equilibrium with the needs and circumstances of the United States in 2025, which I don't want to be heard to defend every last thing every president does, but that's, roughly where I am. Yeah. I think there was a hand behind you. Yeah.
In recent events, and I don't want to get too political with this, but in recent events, we have seen the president use his resources or the resources of the country to in a way just take away the power from another ruler. And
are you talking about Venezuela?
yes.
Yeah.
I'm sorry.
I just want to be clear. But
I want to take this from a non-partisan view.
Okay.
Is the president exempt from the oil that he sold? And a lot of people were very surprised by that, but put the money in an offshore account in his own name, and a lot of people expected that at least the resources taken from that would be used on the country, but not. Is he exempt from those actions?
I heard about that. I'm very suspicious of all these reports like this because they often always turn out to be something else when you look into it. And I haven't had time to look into it yet, in part because I was preparing my talk for that thing to do. So apologies, I'm going to have to pass on that. But if it's true, then it's also relevant to Gary's impoundment issue. That is, if you can take money from a foreign country and sort of keep it within the foreign sphere of presidential discretion, keep it in that system, then that's a whole new ballgame. Yeah. Please, yeah.
So there's exactly one part of government that I can think of that can choose exactly what policy issue it wants to think about, when it wants to think about it, and it is completely unreviewable to anybody else. And it's not the president. It's the Supreme Court. And so there's a parallel history going on here, where the court has ignored every statute that governs its appellate jurisdiction, that has granted itself the authority at any time to look into any case anywhere in any court in this country, state or federal, if it sees a colorable constitutional claim. And it's completely unreviewable. And one way to read Loper Bright is that we are no longer going to give deference, and we're going to remove all of these delegations that you're talking about and give them de novo review to the judges that we will be able to supervise, we will be able to look at. So isn't your history here just seems to me to be, and you could tell the same story, but if I just added like what's going on with federal jurisdiction, the end game, we have two parallel tracks that are basically developing enormous unreviewable authority, and it's just a race now. I don't know who wins it, but it's hard for me to see that you couldn't tell the exact same story, of course.
I don't think so. I love the question. I think it's very important. And I think there's an element of truth in it, which is that the long-term trend of our institutions has been power flowing out from Congress, flowing outwards from the legislature to the presidency and to the courts, especially the Supreme Court. So I think that part is right. But when it comes to the question of who's going to get the lion's share of the pie, I think that there's no question it's the presidency. Let me explain why. The presidency has power that the Supreme Court does not, which is the power to act in the material world outside of producing words, if that makes sense. And this actually goes back to a Schmittian theme, the theme that courts and legislatures come too late to the scene of a crisis. Sam will give you the exact quotation, but he knows what I'm talking about. They come too late because the executive has the power to actually change material conditions out in the world, as we're seeing in our news today. And that changes the legal situation on which the courts have later to act. It changes the de facto situation that confronts the courts. Within law, I would say that I think that account of Loper-Bright is really much too strong. Loper-Bright, a lot of what it does is just relabel Chevron deference as delegated discretion. I think that fits my point. And we've seen since Loper-Bright, the court has addressed Loper situations in 2 cases, and in both cases it's upheld the agency action, pointing to delegated discretion. So I think, I was joking earlier, in French public law, there was this idea that the king never dies, le roi ne meurt pas, and that's true of Chevron too. It's, it's changed its regnal name, but it's still there. And the other thing that constrains the court relative to the presidency is, of course, the ever-present specter that the president will ignore it. I mean, we don't see that happening, in my view, nearly as much as the editorialists say we do, but even if it remains kind of off the equilibrium path, it's still an irrelevant threat for the court. They know that if they go too far, the president may simply ignore their decisions, and that would be very damaging to their kind of credibility and their institutional standing. So I think they're always keeping that in the back of their minds. And in fact, justices have said so expressly. So, yeah, I love your question insofar as both branches are taking from Congress, but I don't think they're taking. I was sort of going around this way, so this gentleman here.
You discuss a trend towards increasing executive power. My question is, are you suggesting a mere redelegation of power towards the executive or a more systemic increase in governmental authority overall?
Well, both those things have occurred. So the scope of the federal government as a whole has expanded quite substantially over the course of the 20th century. And then within that structure, there's been a wholesale transfer of authority from Congress to the president. So both those things are happening at the same time. And, I don't know what to say. Part of the legal drama of the early 21st century has been movements that are trying to, in some way, restore some baseline of reduced national legislative power or enhanced constraints on delegation. And despite a couple of what I would perceive to be largely symbolic successes in those campaigns, overall they have not worked. I don't know if Gary agrees with me.
Exactly right.
Yeah, okay.
Symbolic is exactly the word that's appropriate.
Exactly. So I just think when concerted legal political campaigns make no headway kind of against the winds, I think it's because there's something, real in the world pushing in that direction. Okay, I was going around this way. Yes, sir.
All right, so good talk. Thank you, Dr. Vermeule. So from what I understand about you and from this talk, you seem like a Carl Schmitt guy. I fancy myself a bit of a Carl Schmitt guy as well. So I just wanted to posit, do you believe the friend-enemy distinction holds weight in the current American political climate? And do you think that it should be easier to alter the American constitutional order? Should we make it easier to change the Constitution if we identify an enemy? So like, for example, if we feel as if pornography is threatening the American civil body politic, would you believe that we should deliberately go against the free speech protections in order to protect people from that danger? Or another related case, just give any example.
Okay, first of all, I think that these Schmittian concepts are thrown around too loosely in the sense that just because you're really pissed at someone does not mean that the Schmittian friend-enemy dialectic. I was, I have been writing lately about classical legal theory and the common good, and sometimes I get people asking me, well, there is no common good in the United States in 2025. We don't really think that. As Baudin said, if there's no common good, there's no republic. And I don't think we're yet at the place where there's no republic. So I wouldn't think about it in those terms. As to, I'm not sure what the other thrust of the question was. I mean, do I think that what used to be called morals legislation is generally a good idea? Yeah, I do, but that's really not, I don't think it's related to what I was talking about today so much. Does that make sense? Yeah.
Yeah, the reasons that you were sharing for this trend towards executive authority over the course of decades, centuries, it assumes that those actors are responding to the needs of changing times and people in a very selfless, altruistic way. Maybe not. I was wondering if you wanted to dive deeper into that kind of public choice theory lens to dissect the extent to which self-interest.
I wrote a whole book on it, so that's why I kind of don't want to go into an hour-long video. It's called Law's Abnegation, and you're welcome to read it. I think it's just mixed in the sense that you can point to cases that are what you might call public regarding delegations because of complexity or speed of change in the environment or the needs of growing empire or whatever. And there are some that are kind of abdications that explained on public choice grounds and so on. I think that latter category sort of can cut in any direction. That is, it has no systematic valence, whereas again, the kind of expansion of the economy, the expansion of the American state, the expansion of the American global footprint does have a systematic valence, and that's why we see Congress granting more and more authority to the president, because legislators know that they can't deal with it, to be quite frank. So you have one set of factors that has no systematic valence and another factor that does have a systematic valence, and that's why when you tend to see change over time, if that makes any sense. Yeah. Thank you. Please. Yeah.
I guess I have a microphone for this question. I just thinking about the way you laid this out, it's sort of answering the question of why the executive has sort of developed these features and expanded its broad power. In a lot of ways, it's in response to the same impetus that dictatorship was implemented in sort of the Roman Republic to deal with these.
No, I feel terrible. I haven't communicated. In a way, it's the opposite of dictatorship, because what we've done is we've made the ordinary baseline for law so expansive and flexible that we don't need.
That's what I was getting at.
Okay, I'm sorry. All right, I just want to, that's my core thing.
Yeah, no, I get that. I was more saying that it's the thing that caused dictatorship to develop.
Yes.
Or why we sort of developed.
Right, yeah.
But in the same way that executive power is sort of expanded within the American government, sort of within the American Constitution, lowercase c, we still imagine ourselves to kind of be like these strong Republicans following the Constitution, or at least amongst the broader public. Do you think that there's going to have to sort of be a reckoning in American society with the fact that the president's executive power is expanding in this way? and we're going to have to sort of reconceptualize how we view our own government and view sort of American civic institutions. And if so, and you know, obviously the good historian doesn't like to speculate about the future, but do you have any ideas about what something like that might look like?
Well, that's a great question. It's just so hard to speculate sensibly about these things. I'll leave you with an analogy that's a little bit discomforting, maybe. If you look at elite Romans in the early and middle Principate, they have there's this kind of hangover of Republican theory. So, emperors occasionally talk about restoring the Republic, and intellectuals write each other about could the Republic be restored? Like, could we reinvigorate the non-delegation doctrine or something? But that turns out to be an essentially ineffectual discourse in light of the actually existing legal and structural situation. And it's possible that a lot of what we now see as the constitutional law scholarship about executive power will end up looking like that it just won't have come to grips with the fit part of the story, if that makes sense. Yeah. It's kind of depressing thought, but Professor Hayes.
Thank you. I wanted to get your take on 5 legal concepts that I'm thinking about how they might push your method. So here are the words, and you'll sort of see what I mean. Insurrection, rebellion, emergency, national security, and invasion.
Yeah.
And when those words are part of, let's say, a grant of delegation, and if we take a flexible interpretation to them, how do we think about a situation like that? Is that much more dictator adjacent as a descriptive matter? Because all of those words are sort of get at an extraordinary situation with extraordinary powers, like suspending the writ of habeas corpus or sending the troops in to restore order in American City. And they're part of the positive law as it exists today. They haven't, and people seem to be flirting with invoking them in situations where I think factually it's inappropriate. So just as a descriptive matter, how do you think about when it's words like that, does it fit the same story of expansive American power, or would you think of that as something much more like the classical concept?
No, in fact, I wouldn't. In fact, I think that's a nice illustration, Chris. I actually had it in my text, and I felt I was taking too long, so I didn't get into it. But I think it's actually a nice illustration of how concepts relevant to dictatorship become domesticated and given a very different legal significance through delegation. So there's this thing called the Insurrection Act, which is very much a live topic of discussion today. When the Supreme Court sort of put limits on the president's federalization of the National Guard, they wrote the decision in such a way that those limits would not apply to this Insurrection Act, which the difference being that the Insurrection Act allows the president to use the regular armed forces, not the National Guard, and for straight law enforcement, not just for these protective powers of protecting federal functions and so on. The triggers for that statute are, insurrection and so on, but it's as the president considers necessary. So that it's not whether there's really an insurrection, but whether the president considers it necessary to act against what the president thinks is an insurrection. And that's, I think, an example of how the delegation kind of domesticates these things and gives them almost the opposite meaning. That is, it's not that the president, it's not that we have a dictator who we appoint ex post the existence of the emergency. That is, when we see the emergency happening and then we find the dictator as a special magistrate and send them out to deal with it, we grant this authority under the Insurrection Act back in the 19th century, and then we tell the president, from now on, you have a standing authority to address insurrection through the regular armed forces as you consider necessary. And that's all why I say delegation and dictatorship are almost opposites. It's delegation expands the standing ordinary law rather than toggling between ordinary and extraordinary. Please, yeah. Yeah.
I just wasn't sure whether there was someone else behind me. Thank you. I'll try and put all of my thoughts in a coherent question. I'm not sure that I'll succeed, but I'll try. But it was a great and thought-provoking talk. So you just mentioned now, as you did before, that in so many ways that you have described, dictatorship and delegation are opposite to each other. If we think back to the Roman conception of dictatorship, an extraordinary office used to restore liberty in the Republic, could we then, following the contrast that you drew between dictatorship and deregulation, speculate that in some way deregulation might produce the opposite result to
Delegation.
Roman, yes. That it might produce the opposite result to what the Roman dictatorship was meant to produce. And whether it did in practice or not, that's a separate question. I'm just thinking about the sort of conceptualization of it now. So that is to say, the long-term trend that you have so well identified towards the expansion of executive power through delegation. Doesn't there come a point, would you say, where that trend undermines the principles that underpin the Republic, and it becomes a threat to liberty, to other principles that are very much sort of major preoccupations of the founders?
Yeah.
And I don't know whether they're thinking about dictatorship in the founding era as much as they're thinking about tyranny. And when they're thinking about tyranny, of course they're thinking about a constant factor in all human affairs, and that is sort of the hunger for power, the intoxication for power. It doesn't have to be sort of self-interested, it can be idealistic, it can be, it can be associated with utopian aims, etc., but it is a sort of constant pattern in human affairs that leaders will want to get more and more power in order to enforce a certain vision or to serve very sort of narrow aims. So that is to say, or what I'm trying to say here is this long-term process of delegation from the legislative to executive power, does it reach a point, would it reach a point, in your opinion, where it produces the opposite of what the Republic is meant to produce, and it undermines the Republic instead of sort of keeping it apace with development, which you mentioned, the complexity of the economy, empire and so on, the complexity of the global economy. Doesn't it also, though, just undermine itself? I hope that makes sense.
No, the question totally makes sense. I mean, it's asking for one of these global normative evaluations that make me uncomfortable. I'll say a couple things.
Just a bit of fun speaking.
Okay, fine. I'll play along. Let me give two answers. One, a very legal formalist answer, and one, like a more material answer. So the legal formalist answer is nothing has changed in point of strict legal theory. That is, Congress could repeal the Insurrection Act tomorrow. It could repeal, the very broad grants of discretion in the Communications Act or in the labor laws or whatever. So nothing has changed. That's the very formal answer. The material answer is, well, but it looks more like a kind of Augustan settlement, if you know what I mean. That is nominally Republican, but not in operative terms. Now, is that good or bad from the standpoint of a Republican conception of liberty? Well, we have to avoid the nirvana fallacy of thinking that in a world in which Congress decided more, there was more Republican liberty. That doesn't necessarily follow at all. Congress, depending on the issue, can be terrible from the standpoint of Republican liberty, and the presidency can be better. There have been many moments and kind of places in American history where, for example, the Senate has protected, local oligarchies or hierarchies of Republican unfreedom and domination, so it's complicated, I would put it that way. And I tend to think that, it's hard to say systematically that the transfer of authority from Congress to the president is bad from the standpoint of Republican liberty. I want to be shown some theoretical case why that's so. I think it's orthogonal, as the law professor said. It's like orthogonal to the concept of Republican liberty, and depending on the issue, it can cut either way. Should we make this last one, maybe? Sure. Yeah, that's.
Yeah, I agree with this, but I have a worry, which is this. So in Rome, the dominant philosophy of law was there is natural law, there is a rule of what is just and what is not just. I think we mostly have lost that. There is no strong theory of natural law that is prevailing in the world and that is going to give some meaning to this new power of the president. That's my worry. Yeah.
You have hit on the arc of my career. That is, that's why I'm writing about classical legal theory. Is that the imperial jurists knew that they had a problem about excessive imperial power, and one of their main reactions to that problem was to try to interpret the law in accordance with natural and divine law through the development of reguli juris that idealized the imperial will. I don't know if I'm getting too abstract, but the idea is if you idealize the imperial will and you say things like Baldus used to go around saying, like, the emperor always intends to act in accordance with natural and divine law, that this is your best recourse in a world of, very broad delegated discretion. And I think that's one path that we will have to explore, if that makes any sense. You see the same process in English common law with the development of the idea that the king can do no wrong, which becomes an idealizing maxim that tries to constrain royal authority by saying, well, the king surely doesn't intend to do wrong here, therefore we'll construe the statute in a way that respects natural and divine law. Does that make sense? Yeah.
Great. Well, I think it remains only to thank Professor Vermeule for his lecture.
Well, that was wonderful. We hit the arc of your career at the very end. And, thank you so much, Professor, for being here. Professor Leibovitz, thank you so much for initiating this wonderful conference today. I want to thank all the participants and everyone who participated in preparing for this and everyone who's here today. And we wish you all a good evening. Thank you.